are we going to waste county resources on an individual that doesn't want help? He chooses not to be rehabilitated. He chooses not to use the community sanction. And at some point when he kills someone driving without a license or on methamphetamine, we're all going to look back and say, well, that just happened.
This is the date and time set for sentencing in this matter. Sir, you had an opportunity to review the two reports in this case.
Yes, sir.
And Mr. Trush, are there any additions, deletions, or corrections on either of those?
No, Your Honor.
Are there any challenges to the scoring on the new felon file?
No, Your Honor. I think there's potentially a challenge to OV2, but frankly, it doesn't change the guidelines. So we're not pursuing that.
All right. Ms. McGregor, do the people have any additions, deletions, or corrections to either report?
No, and no challenges to the scoring, Your Honor.
Thank you. Anything on behalf of the people for allocution today?
Yes, Your Honor. I think when you look at this case with Mr. Michels, I've been involved with him since 2025 on several cases, starting with the original case that's now on a probation violation, and then also with several cases during the pendency of that case. And if you look at that case, that was a sentencing on January 8th of 2026. There was 7411 given on that matter. And during that probationary period, Mr. Michels did nothing. He was still violating law. If you look at the criminal history, he had a case in March 18th of driving while license suspended. And then again on March 31st, 2026, was arrested with controlled substance possession of methamphetamine, the case that originally brought him in front of your court. When you look at, and I understand what the recommendation is, and I understand what Crawford County normally does with cases and sentencing, and I understand what MDOC has recommended. But you look at this, and this is a straddle cell. The guidelines are 5 to 23 months. I would not be doing justice. I know I don't reside in Crawford County, but for the Crawford County people, if I didn't argue for a prison sentence, and I would argue for 18 months. And these are the reasons why. Probation is given and community sanction is given for oversight of people that will use those services and for rehabilitation purposes. The defendant was given that opportunity with the possession of methamphetamine under 7411. He chose not to use any of the services when you look at a community sanction. He continued to violate probation, right? He got another driving while license suspended. While he was on bond during all of the cases, he continued to drive without his license. He dropped dirty for meth during the pendency while on bond. So those sanctions and that money and resources for your community are used for people that actually want to be rehabilitated. When you look at the defendant, I say that he isn't an individual that wants to be rehabilitated based on his continued use of methamphetamine. This new case is based on he wasn't reporting to MDOC. He absconded. They went out to his house. They find him at his house. He has possession of methamphetamine. He's enough to maintain a drug house. He has firearms. All of those things show that he's not a community sanction. And are we going to waste county resources on an individual that doesn't want help? And I think that's the argument that needs to be made. You can look at his criminal history and say, well, he doesn't score out on PRVs because of the 10-year gap and all of those things by virtue of statute, and that's accurate. But look at his ability to comply with orders, bond orders, comply with probation orders. He will not comply with that. So we'll be back in court within the next 6 to 8 months on another probation violation because he refuses to take accountability and do what needs to be done. When you look at those cases, and I argued in Judge Burmeister's court under a misdemeanor sanction. I don't live in your county. And in my county, I argue for prison on this for several reasons. The first case that was involved him driving, I believe, and he had a bond violation, driving under the influence of methamphetamine. So you're having this individual on your roads. It's a safety issue for your community. He doesn't take it seriously. And at some point when he kills someone driving without a license or on methamphetamine, we're all going to look back and say, well, that just happened. No, there's avenues that can be taken. He chooses not to be rehabilitated. He chooses not to use the community sanction appropriately. And at some point, that in terms orders a prison sentence. And I was very blunt during sentencing with Judge Burmeister. I said to the defendant, I'll be ordering prison recommendation for you, because at this point, I don't believe you're community sanctioned. And at some point, I'll be a special prosecutor if he doesn't go today to prison and just gets the 8 or whatever months that are recommended. I'll be a prosecutor again on another one of his cases within the next 6 to 8 months that I'll be arguing for prison again, because he will not quit his behavior. He will not use the resources that the court has given him and MDOC has given him and misdemeanor probation has given him and your county has given him. So he's going to continue to violate the law. He's going to continue to use methamphetamine. He had children in the house when he had the methamphetamine in that home. It's a safety issue to his child. So based on the totality of circumstances, I believe a prison sentence is appropriate in this manner, and I would request 18 months, Your Honor.
Thank you. Mr. Trush?
Thank you, Your Honor. Frankly, I couldn't disagree with the prosecutor more on this case. I mean, to start with, she frames the original underlying offense that we're here for the probation violation on as he was driving under the influence of methamphetamine. That's not what bears out in that report at all. What bears out in that report was he was pulled over, driving on a suspended license. There was methamphetamine in the vehicle. There's no indications in the report in any way, shape, or form that he was using the methamphetamine while operating the vehicle there. And that is an important distinction. In regards to this case, again, she frames this as he is absconding from probation. Again, I don't think that's accurate. He was in contact with Mike McFalda. Mike McFalda asked him to come in to report, and it is in fact true that he did not come in and report, and he indicated to Mike exactly what was going on. There was a warrant for him for a DWLS. He knew that. He didn't want to get arrested yet. Mr. McFalda gave him a week to take care of that warrant. That's the background that comes here. The prosecutor frames this as there's methamphetamine in the house and this is a danger to his child. I take a great deal of issue with that. The methamphetamine was found locked in a safe. I'm not going to advocate here and say that having methamphetamine in the house is a good idea, but certainly having it locked in a safe, if you're going to be using that, is among the safest ways to do it. And quite frankly, in some cases, is the safety plan that DHS will put in place if somebody is a user and has that in their home with children in the home. I've seen that as a safety plan in numerous cases. So I take a great deal of umbrage there. Your Honor, sentencing should be progressive. Sanctions should go up as there's continued behavior. And I'm certainly not going to argue to the court that that's not what should happen here. The sanctions should go up, but I think the court should look at a couple things when thinking about that. One, what was the sentencing in the underlying offense? In the underlying offense on this, he didn't serve really any jail. He served 2 days with 2 days credit and was placed on probation. So any jail sentence here is a significant increase from what was done in the last case, a progressive sanction. We don't want to jump right to the highest end sanction of MDOC because, again, what we're going to do then is over punish people who can be corrected with lesser sanctions. In addition to that, there's another huge penalty here that's being sought and will certainly be imposed by the court that's being underestimated. And that's that he's going to lose the benefit of that 7411. And that in and of itself is a significant penalty that he's going to face in this case. And that now he's going to have that on his criminal history, as well as the new charges on his criminal history, which significantly raise his prior record variable scoring if he does continue this behavior in the future. Your Honor, Mr. Michels is a person who is a good member of our community. He is a person who, frankly, for my discussions with him, I think wants to get back to his normal life. He's had a lot of strife in the last year. He's gone through a divorce. He's gone through these cases. I think a jail sentence here is appropriate. Frankly, 8 months seems like a stiff jail sentence to me, given what the last sentencing was, given the penalty he gets by losing the 7411, and given his specific prior record. I think the jail that he's already served up to this date has had a profound impact on him. But I think an 8 month sentence is a steep penalty here and steeper than is necessary. I would suggest to the court the lower end of the guidelines is probably what's appropriate here, knowing all the other things that come along with that. Thank you.
Thank you. Mr. Michels, anything you wanted to say?
I'm terribly sorry for wasting everybody's time. I can do good. I am a good person. I do love my family. I love my freedom. I do a lot of work in the community. I'm a contractor. You know, I go into people's houses in and out. I am trustworthy. I did just go through a divorce. Did kind of knock me down quite a bit. I need a driver's license. That's a big thing. I have a lawyer hired for that. If I could get the chance to do good, I think.
All right, well, I read through the reports in this case. I was already familiar with you generally and your circumstances based on the original case that we had. And then, of course, I read through the new report of the additional criminal conduct that brings you before the court here today. I've listened carefully to what both the lawyers have had to say. They both, I think, done a good job of articulating their respective positions and views of this. And I take what you had to say into consideration as well. And looking at all of those things together as a whole, number one, I recognize that everybody that comes before me isn't just one thing. Everybody has the potential to do good things, and I'm sure it's no different with you. And you've gotten yourself into a situation here that's created a great deal of trouble for you and has made it more difficult to do the good things that you want to do and be involved in the things that you want to do. I have no doubt that, at some point you can get back to that. But there is there's a consequence to be paid for your behavior over the past period of time. And, the probationary period did not go well at all, as you know. Everything Ms. McGregor stated in terms of your violation behavior is absolutely correct. There were no payments at all made towards your fines and costs, and you continue to engage in violative behavior. It is concerning to me, and I certainly appreciate Mr. Trush's argument that if you're going to have methamphetamine in the house with children, the safe is the best place to put it. Versus the best thing is to not have methamphetamine in the house with children at all. And so I don't find that the storage thing is really a mitigating circumstance, and I think that presented a legitimate danger to children. And
May I say something?
sure,
I never had a chance to make a payment. I mean, I could pay my fines and costs off in full tomorrow. I never even got that chance yet. So the money thing's not, the issue, the fines and costs. I did have a prior warrant for that arrest. I had every intention of coming the next day to come see Mr. Mike. I thought we were in agreement with that, but apparently it was a misunderstanding. I got arrested on a Sunday. I was coming to see him on Monday, but I was all signed up for the Grace Center for my counseling, which was prior to that week before I came into jail. So, I had everything on a roll of going.
well, I don't know. You had plenty of time to drive with a suspended license and have more methamphetamine. So,
Okay.
right? So we saw what happened and what didn't happen. And what happened was you got your hands on more methamphetamine and you didn't do any of the other stuff. So not sure the timing is really the most important part of that whole situation. It's what you chose to make a priority. So looking at things as a whole, I do think a greater sanction is appropriate. I do know in the PSI that you would be eligible for the boot camp program. I think that's a good option for you, given that probation did not go well. And I think that's going to provide a different experience for you that may have more of an impact than anything that we've done so far will. So as to the new charge, the court is not going to place you on probation again. I don't see any value in doing that to the community, placing you on probation again when the first term had absolutely no effect. The guidelines, as indicated, are 5 to 23. The court is going to sentence you to 18 months to 10 years on the methamphetamine charge. In the Michigan Department of Corrections, you have credit for 65 days served. I will not have an objection to your placement in the boot camp program, which would allow you to be released significantly sooner than that. And there's, again, all indications that you are eligible for that. As to the maintaining a drug house charge, the court is going to sentence you to 12 months in the Crawford County Jail with credit for 65 days served. That to be served concurrent with the sentence for possession of methamphetamine. In terms of the probation violation, the court is going to sentence you to 6 months in the Crawford County Jail. You do have credit for 67 days served. That time to be served concurrent with your sentences in file number 5549. The court is going to order that your probation be, if you discharge unsuccessfully, and your 7411 status be revoked, the court will preserve any outstanding fines and costs. As to file 5549, the court will order a $130 private assessment, court costs of $325, attorney fees of $350, $136 state costs. You do have the ability to seek an appeal of the sentence. Mr. Thompson, can you assist Mr. Michels since yes, Mr. Church is not here? Yeah, you just got it.
Your Honor, I just have one question for the court.
Yes.
Based on the sentence that the court issued, what does the court anticipate will happen should Mr. Michels complete the boot camp prior to the 1 year county jail sentence expiring?
That's a good point. The court would hold in abeyance any time after that might remain. If he's eligible for the boot camp program and is released between that time, I wouldn't want him to go back to jail after that. So thank you for mentioning that. That's a good point.
Thank you, Your Honor.
You reflect that in the sentence.
Okay, Judge, I'm sorry, can you say that one more time?
So if Mr. Michels participates in the boot camp program and completes it prior to 12-month sentence, the court would hold any remaining jail time in advance.
And that's on the 5502 case?
No, that's on 5549.
Okay.
Maintaining drug house charge.
Okay.
Thank you. Mr. Cheerstead, that'll be in the judgment of sentence.
Thank you, Your Honor.
Your Honor, I don't know if there's a procedure for me to indicate that the defendant has been provided with these. He's indicating he doesn't want to sign anything at this time, and his attorney's not right here to sort of speak to him, so I don't want to.
Mr. Trush, did you hear that?
Pose that.
Yes, Your Honor. I will get, if Mr. Thompson could take the paperwork with him, I'll go up to the jail and speak to him either this afternoon or tomorrow.
All right, thank you.